Could you give like a basic idea or background of the concept of intellectual property and trademarks and branding and set the table for the CZTs to understand what we're going to be talking about?
So a trademark is very much a brand. So think of the Nike swoosh. People recognize that, and as a source of origin of products. So when you see a brand on a product in the store, as soon as you see that swoosh, you know that it's made by Nike. And so you know that there's a certain quality aspect surrounding that product, that it's been vetted by the company that you know and trust for making quality products. And so it's very important to protect that. So that's intellectual property. It's your brand. It's Nike's brand in the case of the swoosh. And they have to be careful to make sure that people aren't misappropriating or misusing that brand. Because if they do, they can lose it.
So to interrupt, it's Nike's responsibility to protect and enforce against other people using it incorrectly. It's not some government agency with whom they registered the brand.
Absolutely, yes, that's exactly right. They have to be out there at flea markets and bazaars to make sure that people aren't selling fake Nike products. Mm-hmm. Because if they let that happen for too long, then their trademark gets lost. I mean, it goes the way of Aspirin and Escalator, which used to be brands that were associated with one particular company for each of them, and they didn't police it. They didn't control how those marks were being used.
So can you differentiate somebody telling their own story that might be in article or book form versus what most people think of when they think of a book is, a publisher publishing a book?
Okay, so that kind of use in a nominative sense to describe your product versus someone else's product or service is generally a fair use. But if you're using Zentangle as a brand, instead of your own brand, but you're using it to imply to customers that this is a Zentangle product, as opposed to your product telling your story about Zentangle. Those are two very different uses.
In publishing contracts I've seen on ones that imply presenting a brand, they all ask that the author say that they own all of the material that is in the book. And in the case of nominative use, that wouldn't apply, right?
That's exactly right. Simply because you're referring to the Zentangle method in a nominative way, there's nothing, you are not suggesting that you own the rights to that mark. And so you don't want to be signing a contract with a publisher that says that, yes, I own that and I'm giving you, Mr. Publisher, the right to publish this work.
What is the exposure of someone who uses someone's brands or trademarks beyond nominative use and claims that in the contract, knowingly or unknowingly, that they own those marks?
It depends on the terms of the contract. Most contracts indemnify the publisher for any misstatements. So if there was something in there, the work that was misstated, that was improper, that improperly used someone else's intellectual property, including trademarks or copyrights, then the person aggrieved by that has the right to seek damages against the publisher. And most of these contracts say the publisher can in turn go back to the author to pay things like legal fees, like their legal fees.
So we have a policy that we allow people to make anything they want with the Zentangle art method. You can tangle your T-shirt. You can make copies of your T-shirt. You can sell your T-shirt. But you can't put our name Zentangle on it. without a licensing agreement. And even though that sounds silly, could you explain why that's a good idea or a necessary idea?
Absolutely. It goes back to protecting the mark. As soon as you put your Zentangle mark or logo on there, there's a perception amongst the consumers that this is a Zentangle product, or that Zentangle has vetted the product and determined that it meets your standard of quality. So it goes back to that Nike swoosh, clothing. And that's part of what the trademark, in order to protect your trademark, your brand, you must do this. And if you don't, then you run the risk of losing your valuable property.
Does the same thing apply if you're giving it away?
Yeah, it absolutely does. No matter what the price point is, we don't want customers to be confused as to where this product originated from.
What other general things do you want to make sure that get communicated in this video?
Well, one thing that occurred to me in thinking about this was that CZTs are out there. It's in their best interest to promote their own brand. And so they should have their own brand that's separate and apart from Zentangle. And it's perfectly, and of course they want to use their CZT designation, and they want to make it clear that what they are doing is teaching the Zentangle method. But first and foremost, they want to be promoting their own brand so that they become recognized as an expert in the field, so that they'll develop their own following and that their own businesses will grow. And so it really behooves them to make sure that they have their own brand identity, and and by doing that, that's going to help consumers understand that, oh yeah, this is from Jane CZT or Jim CZT, an expert on the Zentangle method. But it's not Zentangle. They aren't Zentangle.
Can you talk a little bit about the grammar rules? The verb, noun, adjective.
Right. It kind of goes back to aspirin and escalator. You don't want to use someone's trademark as a noun or a verb. You want to always use it as an adjective, and so that you're using it so it's not you're not Zentangling. You are engaging in the Zentangle method, and so sure. So that's just think adjective. Just don't think you're not gonna Zentangle something. You're not gonna, and it's not a Zentangle. It's a piece of artwork.
I've seen contracts with online training where people, teach some skill at an online school, and the same thing applies, I believe, that you can't assign rights to something that you don't own in a contract with anybody in that case.
That's exactly right, though. I mean, it just goes back to the importance to really have your attorney look at the contract language before you assign it. We can't emphasize enough that it's just fraught with peril to sign another party's contract without understanding all the details. And as you point out, most of these contracts are skewed incredibly towards the benefit of these third-party publishers.
People draw Bijou a lot, the little snail character. We tell people that as long as it's not done for commercial purposes or that it doesn't suggest ownership of the mark, that it comes under the category of fan art, where, in schools, they don't sue the third grade for drawing Harry Potter characters, for instance. Can you comment on that?
Yes, absolutely. You raise an interesting issue. I mean, one is copyright, because essentially what they're doing is looking at your symbol and copying it. And then the other one is trademark, because you have trademark rights in the bijou character too. So let's go to trademark is easier, because as long as they aren't using it to promote, sell a product or service, then there's not a trademark infringement issue. As far as copyright goes, it's very much a derivative work. So they're clearly taking your design and copying it. But like you say, as long as there's no commercial, they're not extracting any commercial benefit from doing that. They're not going to sell these. They're using it for their own purposes, their own sort of perhaps educational value. They're learning by imitating what you've done. Then I think they're okay.
Can you also talk about using brand names, in this case, most specifically Zentangle, in web addresses?
They should not be using any of the Zentangle marks in the URLs, at least the top level URLs, because there's a strong, it gets into trademark use, and there's a strong presumption that, a Zentangle.net is associated, licensed, or otherwise affiliated with Zentangle Inc. And so that's an assumption that creates a likelihood of confusion amongst potential consumers. So we want to avoid that. Your top level domain really ought to be your own brand as a CZT. And if you want to have lower levels where you talk about, where you mention Zentangle, you have a Zentangle page where you're talking about your CZT licensure and your classes to teach Zentangle, that's perfectly appropriate. Just to reiterate, Zentangle should not be used in your business name. Mm-hmm. It gets too close to, business name per se doesn't necessarily mean trademark infringement, but if you're going to promote your business name, then that's something that really should be your brand that you're promoting as the name of your business. Zentangle should not be in that.
I mean, there's been so many people putting out free YouTubes. We are comfortable with people sharing it in that non-commercial, voluntary, excited sort of way. But we're not comfortable about people selling it or CZTs selling it either in DVD or online formats using the brand. Can you talk a little bit about that?
Right. It all goes back to this likelihood of confusion issue. And so certainly if you're using it in the video, you're using the Zentangle marks in a nominative way, that you're explaining that this pertains to this particular Zentangle method, then that's okay. But when the title of the video appears to be branded as Zentangle, as opposed to Susie CZT describes how to use the Zentangle method to create these beautiful pieces of art, then that's where you start to cross the line. So it's important to make sure that you're not implying to potential customers that this is a Zentangle approved video or Zentangle licensed video, or that it somehow has originated with Zentangle. As soon as you start to imply that what you're doing is actually a Zentangle product instead of your own product, you're riding unfairly on the Zentangle coattails, because now you're basically misappropriating all the goodwill that is associated with the Zentangle brand. So use it. Use your CZT designation. Use the marks the way that you're allowed to do in your CZT agreements and on the Zentangle website, and great.